It is truly an honor and a privilege for me to be with you this evening to celebrate those who make the ABA Death Penalty Representation Project a signature program of the American Bar Association, a profound pro bono opportunity for its volunteers, and an invaluable service to the clients that it represents. The Death Penalty Representation Project makes our association better, it makes our profession better, and it helps make real America's commitment to equal justice under law. Our ABA President, Judy Perry Martinez, was not able to be with you this evening, but she asked me in particular to send both her very best wishes and her deepest appreciation to all of you for all you do, and in particular to this evening's honorees. And now I am particularly honored to present this year's Leadership Award to someone everyone in this room greatly admires, and that's Ron Tabak. Ron helped create the Death Penalty Representation Project in the early 1980s, and he's been involved with it ever since. He's a past chair of the project's committee, and of course is currently a special advisor, which is a post he's held, I'm not sure for how many decades, but a really long time. Ron has devoted his life's work to ensuring the success of the project and its mission of protecting and promoting access to qualified counsel for persons who are facing a death sentence. Ron has helped recruit pro bono lawyers. He was on the team that drafted the ABA guidelines for the appointment and performance of defense counsel in death penalty cases. He helped shape many other ABA policies, including the ABA's landmark moratorium resolution from 1997. He is a prolific writer about the death penalty. For example, every year since 2007, I think, he has written the comprehensive death penalty chapter in the ABA's annual volume on the state of criminal justice. And he's a coalition builder. As chair of the ABA's Task Force on Mental Disability and the Death Penalty, he was responsible for the unprecedented joint statement of the ABA, the American Psychological Association, and the American Psychiatric Association on mental illness and the death penalty. And of course, he's been similarly active in outreach to religious groups and to spiritual leaders. And of course, Ron has also directly represented people on death row. One client was Johnny Lee Gates, who served 26 years on death row before Ron and his team proved that he was intellectually disabled and therefore ineligible for the death penalty in 2003. And although he was resentenced to life in prison, Mr. Gates has always maintained his innocence, and earlier this year won a new trial. So many appreciate Ron's counsel because he combines unfailing frankness with his low-key presentation. He has been a role model and a resource to the ABA over the years, and we are deeply, deeply grateful for all of his service. Please join me in welcome this year's Leadership Award recipient, Ron Tabak.
Many, many thanks to the ABA Death Penalty Representation Project, to President-elect Trish Refo, and to all of you for coming tonight, including Murphy Davis and Ed Loring, who made it just in time. In accepting this award, I will discuss the top 10 lessons I have learned while working with or for this project and the ABA on death penalty issues. Number 10, conventional wisdom is often completely wrong. My involvement in proposing what became this project arose from my predicament in 1983 after I contacted LDF about doing pro bono civil rights work. When Jack Greenberg said they'd like me to represent a death row inmate in the 11th Circuit, I said that was ridiculous. I had never argued any appeal about anything in any court and had never worked on a death row appeal. I also thought, based on conventional wisdom, that the death row inmates were clogging the courts with frivolous issues. But I was told that indigent death row inmates were raising meritorious claims, yet had no constitutional right to counsel, so that I was the most qualified lawyer in the country who was available to represent the client, and that I could make a big difference. With the tremendous help of LDF's Jack Boger, we won that appeal, and then, after cert was granted, eked out a 5-4 decision after the Supreme Court took the case. But the whole experience made it obvious that an organized effort should be made to find capable lawyers to represent death row inmates, aided by talented mentoring lawyers. Steve Bright and George Kendall, who had mentored me prior to the 11th Circuit argument, and I floated this idea to the ABA's section now known as the Civil Rights and Social Justice section in 1983. A few years later, the ABA created this project. Number 9, if you happen to be at the right place at the wrong time or the wrong place at the right time, you can end up attacking a Supreme Court justice on behalf of the ABA. The first time I went to an ABA annual meeting in 1988, Justice Lewis Powell gave a speech saying, although not in these words, it was outrageous that death row inmates whose constitutional rights were violated so seriously as not to be harmless error were getting habeas relief in the federal courts. The ABA president, who knew me from an oil industry litigation, turned to me immediately after Powell finished the speech and said that I should talk to the press to refute what Justice Powell had just said. So I held an impromptu news conference. The August 8th, 1988 New York Times reported the gist of what I said. Number 8, if you represent the ABA at a congressional hearing, you may hear some really incredible things. After I had testified before the Senate Judiciary Committee in support of a bill to address racial discrimination in implementing the death penalty, Strom Thurmond said to the next panel that he had represented many people in capital cases pro bono, and none of them got the death penalty. If I had still been testifying, I hope I would have said, Senator Thurmond, unfortunately, we don't have lawyers as talented as you today. We need you to resign from the Senate and go back to representing people facing the death penalty. Number 7, writing an amicus brief for the ABA can sometimes lead to the potential for good. At this project's request, I wrote the ABA amicus brief in Murray v. Geritano, asserting that a death row inmate has a constitutional right to counsel in post-conviction proceedings. The court decided the case 4-4-1, with the one being Justice Kennedy. He said in his concurrence that maybe there could be some circumstances where there might be constitutional right to post-conviction counsel. So we'd almost prevailed and had had a chance to get the rest of the way in another case. Number 6, being listed as an author of an ABA amicus brief can lead to an out-of-the-blue ad hominem attack. In 1998, I was the least involved author of an ABA amicus brief that urged the court to consider the constitutionality of a state's precluding a prisoner from raising in federal habeas corpus the claim that his trial counsel had been unconstitutionally ineffective, but where also ineffective state post-conviction counsel had not raised that claim of the trial lawyer's ineffectiveness. It's a double whammy of ineffectiveness. The Alabama Attorney General's office, in their opposing the granting of cert, included a lengthy footnote denouncing me, saying Ron Tabak doesn't like the procedural default doctrine. So you shouldn't believe any brief of which Tabak has anything to do with it that relates to procedural default. Cert was denied in that case. I hope not due to the Tabak footnote. 15 years later, the court did grant cert on the issue that our amicus brief had discussed and issued the holding we had asked for 15 years earlier. Number 5, sometimes people you never dreamed would be there come to an ABA program presenting you with intriguing opportunities. In 2003, I was annoyed that our program about Gideon had been scheduled at a time when virtually no one would come. Shortly after I arrived at where the program was going to be held, I saw that somebody I recognized was not being permitted to come in because he had not pre-registered and not paid. I approached those asking for his payment, which he didn't look like he was about to give them, and said, please let Justice Kennedy into this program. During the program, I extemporaneously threw out my prepared remarks and pitched all of my comments to Justice Kennedy. In particular, I said his Geritano concurrence had been very prescient and I had discussed reasons for thinking that when the proper case came before the court, he would apply that concurrence to recognize the constitutional right to post-conviction counsel. Unfortunately, it didn't quite ever happen but while he was still in the court, but we could hope. Number 4, the press can describe you as having had an impact that neither you nor anybody else thought you had. In 2008, after New York's death penalty had been rendered moribund by rulings of New York's highest court, the Albany Times-Union editorialized that the law should never have been enacted, stating, quote, "It's one thing for a law to be struck down by the courts despite the best efforts and legal advice of the lawmakers who crafted it, but it's quite another thing when the warning signs are everywhere." That was the case back in 1995 when Ronald Tabak, a New York City attorney, warned that the new law raised the danger of pressuring juries to unanimously vote for the death penalty to avoid the possibility of parole. As it happens, that was what the Court of Appeals said, unquote. This editorial led one of my rabbis to decide that I must be a prophet. Number 3, if you suggest something, expect to have to do it. I proposed that a task force be formed regarding mental illness and the death penalty. The Civil Rights and Social Justice section agreed but said I should chair it, even though I didn't know very much about mental illness at that time. There seemed to be universal agreement about only one thing, that there was no way that the psychologists and psychiatrists would agree on any proposal regarding mental illness and the death penalty because they liked disagreeing with each other so much. But the task force created a proposal that was adopted by not only the ABA, but as President Refo said, also by the American Psychological Association and the American Psychiatric Association. We drafted the proposal after I insisted on having the task force members explain to me what they were saying and tell me why they were taking the positions they were taking. Almost everybody on that task force is convinced that I was playing dumb and I knew all along where I wanted the thing to come out and what I wanted the proposal to be. But I was not playing dumb, I was dumb. But after getting task force members to explain the subject so that even I could understand what they were saying, as I always did with my expert witnesses, I helped them see that what they were arguing about didn't make any real difference, no matter how much they enjoyed arguing with each other. Number 2, sometimes one must advocate that the ABA not take a position that, while it would reflect your personal views, would undercut the ABA's impact on the issue at hand. Thus, Emily Olson Galt and I both told an ABA section a few years ago that the ABA's moratorium position has greatly helped this project succeed in improving the quality of counsel in capital cases and has otherwise helped lead to dramatic drops in new death penalties and in executions. Most leading opponents of the death penalty are pleased with the ABA's impact and think it would have much less impact if it were to call for abolition. Today, it is particularly crucial that we point out the even greater arbitrariness and capriciousness in implementing the death penalty now than when this project was created. It is especially perturbing that a high percentage of those now being executed are from jurisdictions where new death sentences have been few and far between, and even zero, and it's often obvious that death would not be even sought if their cases were to come up today. Number 1, when you introduce somebody you greatly admire at an ABA program, be sure you know the background of how the person came to be invited. One year, this project held a program in Chicago. When I learned that NPR's Scott Simon would moderate the program, I volunteered eagerly to introduce him. Since then as now, his Saturday weekend edition program was my favorite program in any medium. I pulled out all the stops, citing many examples of how wonderful he was. When Mr. Simon got to the podium, he said he would have been more impressed by my introduction if he had not known, which I had not known, that he was there only because the original moderator couldn't make it. Tonight, I do truly thank President-elect Refo, and I know you're in for a great treat when you hear the remaining introducers and speakers, and I thank you for an award for which I could not be more grateful.